One of the most important provisions in any software agreement is the limitation of liability. What's reasonable, what's unreasonable, what should you be asking for, and more importantly, what should you be getting? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For the last 20 years, I've drafted and negotiated ERP-related contracts, and I've litigated failed ERP implementations in courts across the country. The limitation of liability clause is one of the key components of any software agreement. And the purpose of the clause, as you might suspect, is to limit the party's liability. And I think it goes without saying that as a customer, you should never enter into an agreement where you have unlimited liability. You don't want to subject your company to exposure, monetary exposure, that can put your company out of business. The limitation of liability provision really needs to be capped, and there are a variety of ways to do that. One of the most common caps that we will typically see in the contracts that we negotiate is a cap on the party's liability of the fees paid or the fees paid due and owing under that contract. And I think that's generally a reasonable ask on the part of the customer. What you will see from the vendors, though, is they will limit that liability cap even further, and the way that they will do that is it will be limited to just that particular order form. So it'll be a subset of the actual fees paid, and that it will also be limited via time. So they will say, okay, well, we will limit liability for both sides at the amount of money that you have spent on this particular order form in the 6 months prior to the issue giving rise to the liability. That's a relatively common structure, and I think that's a structure that I would typically want to avoid as an attorney representing you, and I think it just doesn't provide you with enough of a remedy. I mean, if you've got to sue and there's massive liability on the part of the vendor, be it from fraudulent inducement, negligent misrepresentation, breach, whatever it is, you're going to want to have a meaningful remedy. You're going to want to be able to go after that software vendor and get some real, monetary, a real monetary amount to compensate for whatever damage that they've brought on you because of their breach of contract. And I don't think that a subset of the amount of money that you spent over a very narrow period of time really is going to get you there. The cost of litigation these days, I mean, it can be $400, $500, $1 million. And so, it's not going to make sense if you're looking at spending hundreds of thousands of dollars in legal fees when the amount of money that you can recover is a very narrow subset of the amount that you've spent. And so that's not a scenario that we would typically recommend. And I think the amount of leverage you have is really going to dictate what kind of cap you're going to be able to agree to. And remember, this is a two-way street. You're limiting your liability, and I think it goes without saying that a narrow limitation of liability for you is probably good. But because this is a two-way street, you've got to think about what you can recover from the vendor. And so this narrow limited liability is not going to be good if you're trying to recover money from the vendor. And I think somewhere in between is going to make sense. You might want to consider an aggregate liability that is going to aggregate all of the money that is associated with that contract. So for example, you might want to include the software licenses. You might want to also include any maintenance and support fees that you have spent or are spending. You might want to also consider including professional services, implementation, integration services. And so now that number starts to be meaningful, and it really does get you to where you need to be if you were to have to litigate the contract. Again, I think it all goes to how much leverage you have. If you're going to be subjected to some sort of narrow limitation of liability that maybe is, a subset of the total fees paid, and it's going to be, restricted further by time, whether it's 6 months, a year, 2 years, whatever it is, I think you want to consider what we would call a supercap, because there are certain types of damages that are going to be associated with these types of deals that you're going to need more recovery. So for example, direct damages, maybe that's a lower number, but for any breach of confidentiality, maybe that is an unlimited number, or it is a super cap set at a multiple of the fees spent. So instead of total fees paid as a limited liability, you've got 5 times fees paid for something like a breach of confidentiality. I think you want to consider including in a supercap or having a separate supercap damages that are incurred because of a data incident, data security, cybersecurity, whatever that might be. Those types of damages typically need to be carved out from that cap, and you want to subject them to some sort of multiplier or super cap. I think as you're going through these concepts of limitation of liability and what's reasonable for your company, you have to have a practicality, and you've got to use common sense. You've got to know who you're dealing with, how risky the transaction really is, and what you need to do to adequately mitigate that risk. I think if you're implementing or integrating mission critical ERP software, in the liability that you could incur, or the vendor, the amount of damages that you could be subjected to because of a breach by the vendor, if that's going to be incredibly high, then that's something that warrants a very high cap, and you're going to want to negotiate it that way. If, on the other hand, the software is, I don't know, some sort of single sign-on software that doesn't present a huge risk, maybe you don't need to spend as much time negotiating limitations of liability. But I think in any contract that you're going to see, this is something that you are going to need to address. And the takeaway from this video really would be, don't enter into contracts that don't limit your liability. You don't want to have unlimited liability, and you want to be able to recover damages in a way that makes sense, especially with respect to data incidents, confidentiality breaches, intellectual property issues. All of those you really want to account for. If you have any questions about anything in this video that we've talked about, feel free to reach out to us at taftlaw.com. We'd love to talk to you and point you in the right direction. The purpose of that agreement, like you would suspect, let me start over again. Sure. ERP agreements, I lost it. One of the most important